Great.
Great. Are you guys ready for some wonderful information to come your way? Say yes.
Yes.
Great, great. Well, we want to welcome you to our 7th event for our gubernatorial series. That is great. Thank you for showing up. Today we have a treat in store for you. We have Broward College's own Dr. Paul Moore, who is the Associate Dean of Business, Accounting, and Paralegal Studies here at Broward College. So give you a little background about Dr. Paul Moore, and then he is going to speak to you today. Paul Moore was born and raised in Charlotte, North Carolina. He graduated from the University of Chapel Hill with degrees in both political science and African American history. Thereafter, he attended Howard University School of Law and graduated with a doctorate degree in law. He also has a master's degree in leadership with a concentration in education from Nova Southeastern University. He has worked for the United States Patent and Trademark Office and Northrop Grumman. He was a faculty member in the Business Administration Department here at Broward for the last 4 years. Currently, he is serving as the Associate Dean for Academic Affairs, Business Administration, Accounting, and Paralegal Studies. He has also been a practicing attorney for several years, focusing on personal injury, will, and trust. He enjoys reading, sports, and spending time with his family. So, please welcome Mr. Dr. Paul Moore.
Yay, Dr. Paul Moore, yay, awesome.
Thank you guys. Thank you guys so much for having me. I don't know if you're here for the popcorn, but either way, I'm excited to see you. I'll be very direct in my comments. I want to start briefly about telling you what today is not about. So I'm going to treat this just like I would a classroom, which means everyone is a volunteer. So I'll sporadically call out and ask for your opinion, and we'll do that in a responsible way. Is that okay?
Yes.
What today is not about, today is not about religion in any way whatsoever. Today is not about judgment. Today is not about anything that you may feel personally. None of those things are relevant to our discussion today. And I'll get more into detail about why that is. Okay? First, let me tell you about myself. And thank you again, Dr. Jackson, for that wonderful introduction. I grew up in Charlotte, North Carolina, very much a part of the South, in a Christian family. I had 2 wonderful grandfathers that are now deceased, that were both ministers, one Presbyterian, one Baptist. I spent a lot of time at church, from the choir to usher. I used to record. I did a lot of things in church. I spent a lot of time there. Went on to Chapel Hill. I'm a very proud Tar Heel. Our football team is going through changes, but that's okay. But nonetheless, after all of that, to make a long story short, I went on to law school. And it was there where I was forced to learn to, in essence, divorce how I felt about personal issues as it related to legal issues. And my hope today is not to convince anyone of anything, certainly not to sway anyone of anything else or change someone's religion or personal belief. It's exactly the opposite. My hope today is to get you to see that what you may feel personally is not relevant in a legal proceeding. In fact, it's objectionable and it's grounds for a mistrial, technically speaking. So with that as the backdrop, I want to introduce you to some controversial concepts where you may disagree with someone's personal choice while sustaining their right to choose it. What do you mean, Professor Moore? I'm glad you asked, so let me explain. If I went home tonight, which I probably will, and had a glass of wine or 2, preferably red, some of you may object to that choice. You may feel a way about my decision to drink alcohol. For some of you, that may violate your personal belief. okay? And it may even violate your religious belief. But do I still have a right to choose to do that activity? Well, the answer is yes, but with certain conditions, right? I'm 21, close to it, but I'm 21, so I have the right to purchase alcohol. We agree on that? Let me throw another example. Is Dr. Tunks here? Dr. Tunks, raise your hand. Let's look at her in the back. Let's go back almost 40 years, 1967. Dr. Tunks and I, single people, we meet on the beach and we fall in love. All we want to do is get what? Married. Guess what the law said in 1967 if we were in the state of Virginia? No can do, because you are African American and she is Caucasian. Do you follow where I'm going? Mm-hmm. Conceptually speaking, there are still people in the country that would disagree today if I married Dr. Tunks in 2014, solely on the basis of what?
Race.
Race. Because I am African American. But would you all agree that I should have, or we should have the right to choose who we should marry or who our mate is? You guys see where I'm going? I'm trying to introduce you to things that you may personally have objection about that don't transfer over to an illegality. I want to give you a couple more before we get into more legalese. Gambling. How many of you know Florida is the 5th or 6th largest gambling state in the country? We just tried Sunrise. I mean, we have casinos, some of the largest ones in the world, absent Nevada. Are we aware of this? We're a gambling state. This too is objectionable in many religions, this idea of gambling. Yet, any of us can choose of age to go to a casino right now and blow all of our money. No one will arrest you, and no one will stop you, because it is your personal choice. You guys following me? Yeah? It's in that spirit that I want to get into this issue of equity. Does anyone know what equity is? Has anyone heard of that term? The term equity? No? Anyone? What's equity? Huh? Yeah? Anyone want to take a shot? Yes, sir.
What you have built up, what you acquired.
Okay, what you have built up, what you've acquired. Anybody else? This term equity, what is that? Equity loans? Okay. What about equity in the context of marriage? What could we be talking about there?
Shared assets.
Shared assets? Okay. Anyone else? What equity is, guys, equity is synonymous with the word fairness. Okay? And we use it as a remedy outside of contract law. Okay? So let's take a step back. To have a contract, and I'll relate that to marriage very soon, you have to have 4 things. A valid offer. Okay? So one must offer you something that has a right to offer it. You have to accept that offer. Okay? You can do that any number of ways, by agreement or performance. And you have to have consideration to support that argument, to support the contract. So if I'm purchasing land, the consideration would be, I'm giving you money in exchange for you giving me a title. That's the consideration. Does that make sense? The last part of it is you can't have any defenses that would negate the contract, okay? Some of you here may be 17. If we drop a contract right now and you sign it and I sign it and I tender you money, it still may be illegal because of your age. So we look at defenses to an otherwise valid contract. You guys still with me? Mm-hmm. Yeah? So where am I going with this? If I asked you what it meant to get married, what would you say to me? What does it mean to get married? Let's get into it. I want to know what you guys think. Forget Professor Moore. When you decide to marry, what are you doing? Being vulnerable, putting yourself out there. Okay, anything else? Anybody?
Finding your soulmate.
Finding your soulmate? Okay, good. Anything else? It's a merger in a financial respect. I'll certainly get into that.
Sharing your life with that of another.
Sharing your life? Okay, good. It's a commitment? Okay. Do you have to sign anything to get married?
Yep.
Who says yes? Let's see hands.
Marriage license.
Who says no? Oh. What is the significance of you signing a document to pledge your loyalty to another? Some of you see where I'm going. What did we just define a moment ago? Contract. That's exactly my point. Notice I haven't talked about how I feel. I haven't talked about anyone's religion. As a matter of law, what you are doing is executing a contractual document. It is analogous to going to McDonald's and buying some fries, getting a receipt. It may mean something to you as a religious matter personally, but that is not inferred upon others who do the same activity. What are you saying, Professor Moore? What I'm saying is this. If, let me stay with Tunks because she was volunteering with me. If Professor Tunks and I go down and get married, before we do that, we have a religious ceremony. Let's leave it open-ended. I don't want to get attacked. Let's just say it's a religious ceremony that we conduct on a Monday. We don't get down to the county court or clerk of court, so circuit court, to sign our contract until Friday. Do you follow my example? Do you guys follow me? On Wednesday, are we married?
No.
Who says yes? We had a religious ceremony Monday. Our friends came, we sang, we ate cake. Our guests gave us gifts. Are we married on Monday? No. Sir, what do you say?
Oh, I say yeah.
Yeah, tell me why.
Because I believe, you had, confessed out openly in front of witnesses. Just like when you signed the contract,
Okay.
It's before witnesses as well. So, yeah.
Okay.
You won't, honestly, mess around throughout the week. And Friday, okay.
Okay. Good. I want more opinions. I don't want this to just be me here. That's anyone else? Are we married on Monday, Tuesday? Jenny?
Married in the eyes of God.
You married in the eyes of God? Okay. One more person. Yes, what do you say?
I think you might feel like you're married, but legally I don't think
Is there a difference?
you're married. Yeah.
And that's my point. Do you guys see it? To you, you may consider yourself married without ever signing a document with the state. Many people do not. But is that the same under man's law? It is not the same. In other words, if I did the converse operation and said, Dr. Thompson and I never had a religious ceremony, and we went down to the circuit clerk of court on Friday and signed a contractual document, will we be married? Yes. Do you guys see what I'm saying? In other words, the religious connotation is an individual one. I don't seek to disturb that. I don't seek to disrespect that. I seek to divorce it from what is legal, because that is an emotion. That is a feeling that is unique to you. For example, in this country, we have people of Christian faith, Jewish faith, Catholic faith, Muslims, Buddhists, and on and on. Is that true? Should we treat those religions as equal under the eyes of the law? Are they equal? Should we respect one over the other as a matter of law? The answer to that legally is no. And so that's the point I'm trying to make to you. Dr. Jackson was kind enough to illustrate that I do wills and trusts as a matter of practice. So the reason I care so much about law is because it's all that matters in my business. I tell my students, when you raise your hand and tell me how you feel in class, take me to the coffee shop. Class is the courtroom. to allow them to separate how they feel, which should be respected, from what the law says. If you wrote to me how you felt on an exam, you would fail. You might feel, Professor Moore, you guys got married on Monday because my religion said so. And as a matter to you personally, that may be true. But my question is a legal one, and the legal answer is definitive. You were married on what day? On Friday. If you don't believe that, then try to pass away on Wednesday. Oh, Professor Moore, you're being extreme. Am I? Let me explain. How many of you know under Florida law, the only person you cannot disinherit is your what? Say it again? Spouse. The person you signed the contract with. Not your children, not the person you love, not the person you live with. The person you signed the contract with. That's the law. So much so that if you had a will that said, I hereby devise and bequeath all of my assets to my lover Jane, she is who took care of me, not my wife. She is who stayed with me during the rough times. What would I tell you when you come to my office and it's time for probate? Sorry. Have to set this aside. As a matter of law, you cannot disinherit your spouse because you contractually agreed between you, your spouse, and the state not to. That's what you did, whether you realize it or not, when you signed that document, that contract. Professor Moore, I'm not convinced. Let's go further. Some of you have had the displeasure of getting divorced. Can we go there? We still okay? All right, we're adults, so let's do it. What does the court do when married people divorce? Let me tell you what they do. They enforce the contract you signed. If you're married over 10 years and certain other contingencies, you have agreed to share half your retirement with your spouse, notwithstanding whether you break up in the future. If you married someone and have property prior to that, you've agreed that they have an equitable interest in that property because they help increase the value, assuming there is any. You've agreed to a number of things that may or may not have been understood to you when you sign the document. Okay, how are we doing? Yeah? Let's go a little bit further. Let's just look at what Florida is under Florida law. How many of you know in 2008, we passed Amendment 2. I'm saying we as Floridians. Define marriage as what? One man and one woman, right? Should only be a man and woman, Professor Moore. I object to people of the same sex marrying. My question I keep posing is that a personal objection or is it a legal one? Because if you were in my class, I would have you brief that and say, go support it with what the law says. Therein lies your problem. We're not convinced? Let me read you a couple of things the law has said. Are we ready?
Yeah.
With respect to Florida, on July 17th, Judge Louis Garcia of the 16th Circuit Court overturned Amendment 2, ruling that it effectively made same-sex couples second-class citizens. Not reading Professor Moore's opinion, just citing some legal language for you to ponder. On July 25th, Judge Sarah Zabel, Florida 11th Circuit Court, ruled similarly to overturn the ban in Miami-Dade County. Let's keep going. On August 5th, Judge Dale Cohen of Broward County, are we listening? Because that's us, ruled the ban was unconstitutional. These are judges, many of which I'm sure have personal feelings against the very conduct they're ruling in favor of. But that's our intersection. That's our divorce. On August 21st, Judge Robert Hinkle, U.S. District Court, Northern Florida, ruled the marriage ban was unconstitutional, making him the first federal judge to rule on that issue in the state of Florida. And Judge Diana Lewis of Palm Beach County Circuit Court ruled the same in a probate case. Now, is it me, or all of these people just happen to like the conduct they're ruling on? Clearly, what they are conducting is a legal analysis. That's the point I'm trying to bring us to. I listen to our discourse as a society. We talk about how we feel. I feel this way. Things should be this way because I feel it, because I personally believe it. What about the respect that you want for your religion that you want to give to other people? What if I don't believe it? Do I have that right? Do I have a right to disagree with you and choose what I want to do with my life personally? Do you have a right to compel upon me your belief as an individual, legally speaking? Some of you are thinking, that's good. Let's go on. I want to take us to a higher court, and we're going to get into some equal protection, some 14th Amendment, 5th Amendment issues. Give me one second. And I want to give you more legal explanation of what is happening across the country. Okay, so we've got a little snippet of what's happening in Florida, right? Miami-Dade and Broward County specifically. Let me show you what the Supreme Court said. This is our highest court in the land. They are the law of the land, whether we agree or disagree with them. Are we familiar with the Supreme Court? Yeah? Okay, let's pretend we are. I'm nervous for some of you. Okay. There was a case in 2013, excuse me, in 1996, where we called the Defense of Marriage Act. Anyone familiar with that? DOMA? Anyone heard of DOMA? Maybe? Okay. In other words, DOMA disallowed for same-sex couples to be recognized as a matter of federal law. Okay. In 1996, the Supreme Court overturned that in a 5-4 decision. I want to read to you what they said. Speaking for the majority, Justice Kennedy wrote the following. Are we listening? The federal statute is invalid for no legitimate purpose, overcomes the purpose and effect to disparage and injure those whom the state, by its marriage laws, sought to protect in personhood and dignity. The justices went on in Hollingsworth versus Perry, in United States versus Windsor, 2013 cases, and stated, by seeking to displace this protection in treating those persons as living in marriages less respected than others, the federal statute is in violation of the 5th Amendment. Have I talked about how I feel yet? Have I talked about my religion? Why not? Because it's not relevant, and neither is yours. That's why we're here. Let's take a look at the board. What's your name? Sandra has volunteered to read this for me. Thank you, Sandra. I did the same to my classes. That's wonderful. Can you see it from here? Perfect. Don't be shy.
Equal Protection Clause of the 14th Amendment. The Equal Protection Clause of the 14th Amendment of the U.S. Constitution prohibits states from denying any person within its jurisdiction the equal protection of the laws. In other words, the laws of a state must treat an individual in the same manner as others in similar conditions and circumstances. The Equal Protection Clause is not intended to provide equality among individuals or classes, but only equal application of the laws. The result, therefore, of a law is not relevant, so long as there is no discrimination in its application.
Let's give her a hand. Excellent. I put her on the spot. So, for all of my future lawyers, this is the issue. Does the law discriminate in its application? Otherwise, this is not relevant. How do we know, Professor Moore? We know by asking one question. Are we treating people similarly situated the same? That's the legal question. Okay? So let's get right to it. What is the legal difference in a heterosexual couple marrying versus a gay couple by operation of law? We agree they're being treated differently, as in not the same, because in Florida, those individuals cannot marry. We agree on that? Not yet. So they are being treated differently. What is the legal reason for that? What would justify the application of those individuals to be treated differently? I want to give you an example. We have legal discrimination in this country, and that can be a good thing. Felons. You come to my office, you fill out a job application. I can ask you if you have a criminal background. You can check, yes, I've been convicted of armed robbery, but it was 8 years ago. I'm a new man, new woman. I can legally say, I am not hiring you for that purpose, and that is lawful. But let me show you the difference. The difference is, before you were convicted of that felony, you had due process. Gideon versus Wainwright, you had the right to counsel. You had a right to be heard. You had a right to go before a tribunal and say, Your Honor, it wasn't me. Sixth Amendment, you had a right to a jury of your peers that was impartial. You had a right to choose to testify. Fifth Amendment, to not incriminate yourself. After that process, you became a felon. Do you see the difference? What did gay people do? Was there a process involved? Where was the due process element that we just decided that this right should not be conferred upon a class of people because we may personally disagree? Where's the due process? Ma'am?
It was bothering me what
Come
you
on.
guys said about.
Why are you asking a question?
You don't want the mic? Okay.
You guys can hear me? I don't know.
Not really. Not really.
Don't hear. Go ahead. I want you to be heard.
The question, it goes back to what you had read on the paper over there about second-class citizen. It was bugging me, like, what is that? What is a second-class citizen?
That's a great question. Tell me your name. Camille, excellent. What's a second-class citizen? Camille, the answer is we used to be. You as a woman, me as a person of color. We used to be property. We used to be able to not vote. Women have been barely voting for 50, 60 years. These are new concepts. I could just marry Dr. Tunks in 1967. That's not even 50 years. That is second class. In other words, other people having rights that have not been conferred upon the rest of us without due process. And that's the distinction. In other words, we do allow individuals to be treated differently for a cause. You understand what I'm saying? Let's go a step further with this. I ask you a question. Is the law being applied equally regarding who can, or conversely, who cannot get married? Some of you are seriously thinking about that now. That's good. I want to pose two amendments to you. None of this is Professor Moore's opinion. It is all constitutional, judicial, or Supreme Court. Do we agree? So let's look at what the law says. That's what we're here for today, right? The First Amendment prohibits the making of any law respecting an establishment of religion. Whoa, Professor Moore, what are you saying? Can I read it again? Well, let's do that. It prohibits the establishment of any religion. First clause. Why would they put that first? In the First Amendment, they put it first because of its significance. They put it first because they wanted to confirm that reasonable people can disagree. They put it first because the same way you have a right to be Christian, Jewish, Catholic, or something else, I have the right to be nothing. That is my choice. Should that choice be respected? The same way your choice may be to be religious. That's the question. Let's go on. Impeding the free exercise of religion, abridging the freedom of speech, infringing on freedom of the press, interfering with peaceful assembly, or prohibiting the petition for a government of redress. For any of those who have taken my class, you would understand the First Amendment is also about freedom of association. I may want to join a fraternity. I may want to associate with people who are like-minded, like me. That is a choice that is guaranteed to me constitutionally. Should it be different if it's a different class of people? Legally speaking, should they not have the right, even if I disagree, to choose who they associate with and what they do with consenting adults in the privacy of their own home? Now, the irony of the discussion, and I've had many of these debates, is a lot of people that hold these near and dear opinions, they don't like that coin to be flipped. When I get to asking you what you're doing in your bedroom, oh, wait a minute. Okay, let me step back. When I get to asking you who you associate with, what you do in private, what those Google searches would say. Come on, Professor. We don't like the coin flipped on us. But sometimes we are more comfortable flipping that coin on other people. The law should apply equally. The first thing you saw in my slide was Lady Justice. What does she have on her eyes? Why is that? Why would she have a blindfold? She shouldn't see anything. She shouldn't see gay, straight, heterosexual, homosexual, Catholic, Jewish. She should not be able to see. Some of you are thinking, that's good, but we're going to go deeper, so hang on. Oh, wait. Take a look at the Fifth Amendment. I just talked to you about constitutional rights. What does it mean to have a Fifth Amendment right of life and liberty? What does that mean to some of you? Anybody? I see Dr. Stav in the back. His hand is up, and I thrive when I see volunteers. That's wonderful. Dr. Stav, I appreciate you jumping in like that. What does it mean to you? I do the same to my students. When you read this notion that you should have the right to not be deprived of life and liberty, what does that mean to you?
You should be able to live your life as you see fit within the guidance of the law.
What if John or Jane Doe is gay? And I personally disagree with that lifestyle. Does that change the analysis legally?
No.
Do you guys understand where I'm going? The only qualifications that matter here is if these adults are consenting, meaning they are choosing whatever their conduct is, they are of age, and they are in an appropriate place, their home. That's the only qualifications here that legally matter. I have not once told you what I think personally, because it doesn't matter. When I get into how I feel as an individual, where do we go? The coffee shop. That's where we talk feelings. Because in a courtroom, feelings are objectionable and subject to a mistrial. They have no place in a legal analysis. We're getting somewhere today. Let's keep going. Fourth Amendment. I want to get someone to help me with this. What's your name, sir, in the blue?
Mark?
Mark. Your hand was up, right, Mark? Perfect. Mark, that's great. Go to the Fourth Amendment. Can you see it?
Yeah.
Read for me what it says.
Fourth Amendment of the United States Constitution protects people from unreasonable searches and seizures by the government. It allows for people to be safe and secure regarding their personal effects. However, there are 3 exceptions. 1, warrant. 2, probable cause. 3, articulable suspicion that criminal activity is afoot.
Okay. Wish I saw some of my criminal litigation students. They'd be able to write that. But I digress. So let me go here, Mark. Why would I put something like this on the board? What does it have to do with the discussion at hand in terms of equity in marriage? What does any of this have to do with anything? Come on, someone give me an analytical mind. Have an opinion. What do you think? Why would this be on the board?
I think it's just to prove that the law is the law, but there are exceptions to things.
Right?
So you explain.
Okay, good, good. Anyone else? Yeah? Yes.
I'm trying to recall, wasn't there something some time ago where law enforcement busted in and into someone's bedroom of a homosexual couple engaging in
Excellent.
something? And
That's an excellent point. There was a case, Lawrence versus Texas, if I'm correct, in 2003, where a neighbor happened to look over out of the window and saw 2 men engaging in homosexual activity. Are we okay? Are we adult enough to deal with this? Are we? Okay, just making sure. To make a long story short, the police were called and these men were arrested because this was a violation of Texas law. This case went all the way up to the Supreme Court, and I wonder what they said. Now, with all we've discussed today, one of you tell me what they said, because we should be on to what they said already. So let me throw my qualifications in. These were consenting men of age in their own home, the privacy of their home. What do you think the court said? Anybody? Anyone? What do you say?
Legally, it should be fine for them to do that because they're in their own home, they're consenting adults, and yeah.
And that's exactly what the court said. Now we're getting it. The court struck it down. They didn't strike it down because they were in agreement or in accord with what those men were doing. They struck it down because that was not of legal significance. They struck it down as a matter of law. It's a great point. The reason I put the Fourth Amendment up here is if you read the context of the Fourth Amendment, I'll get right back to you in a minute, it talks about this notion of being free from government intrusion into our lives. My constitutional law professor from Howard would be so proud right now. He used to make us carry a constitution. I hated it, but it came in handy. The point I'm making is you will not see the word privacy in the United States Constitution anywhere because it is not there. Trust me, I have read it. The word privacy is inferred as a right to us by the Supreme Court within the context of the Fourth Amendment. This is how our notion of privacy is derived. Can the government take my phone, go through it? Can they monitor my email? This is the reasonableness test that the Supreme Court has identified in which the government can search and seize. They have to meet one of these 3 criteria. They have to go before a tribunal and say, Your Honor, we have witnessed Professor Moore going in and out of the crack house. I'll just pick on myself, I'm trying to lighten it up. We have seen suspicious objects protruding from his pockets. He is driving a brand new Cadillac with no job. Whatever. We have reason to think that he might be selling drugs. We would like to, in lieu of that, tap his phone, but we need your permission. We would like to enter his home without his consent, but we need your permission. This is to keep the government from running amok. So I ask this question. With respect to gay individuals, are they entitled to these rights? Should the government be able to regulate private conduct without meeting one of the 3 constitutional criteria? That's the legal question. Now, if John is gay and is doing all the things I was doing, i.e. selling drugs, he should be tapped. The warrant should be signed because it has nothing to do with his lifestyle. It has to do with the objective basis of being a drug dealer. Okay? That's the idea I'm trying to introduce to you. I want to run some other numbers by you for your consideration. Are you still here?
Yes.
I hope so. We're going deeper. 19 states out of 50, that's right under 40%, now have same-sex marriage. Some of them have gotten to that position in different ways, i.e. ballot initiatives, legislative acts, or rulings from the court. Listen to this list. California, Connecticut, Iowa, Massachusetts, New Jersey, New Mexico, Oregon, Pennsylvania, Delaware, Hawaii, Illinois, Minnesota, New Hampshire, Rhode Island, Vermont, Maine, Maryland, Washington, D.C. Professor Moore, what's your point? My point is, there are 31 states, including our dear state, that do not allow this right, that do not allow people to choose to marry who they wish based on gender, what we would call sexual orientation. So in essence, the country is almost split, if you will, as a matter of numbers. Okay? What I want to propose to you is some other questions for us to think about. Okay? My first question is, what is the legal reasoning that 2 consenting adults that are of legal age should not be able to choose who to marry? That is my question. Now let me say it again, because the question has a qualification. I asked about not your religious belief. I asked not about how you feel. I asked about the legal reason that should not occur. I want you guys to think about that. Are we able now, as a matter of sophistication, as a matter of analytical reasoning, to respectfully disagree with how someone may choose to live their lifestyle, while equally standing up for their right to choose to live it? When I told you all when I first started, that when I get home tonight, I've had a heck of a week. My boss is here. And I can assure you that I will have a glass of wine or 2. I was not joking. And equally, in all seriousness, that may offend some of you personally. Some of you may not drink at all. That's a personal choice. But I qualify it to say the only thing that legally mattered is whether I was of age. Let's just say I'm close to 21. So would we agree that I have the right to choose that conduct in my home? Who would agree with that? Should I have a right to choose to drink alcohol? Who would disagree? Okay, so we're unanimous. What I'm trying to show you is a conceptual link to show you it's no different. It is no different than the very people who sit here and say, Professor Moore, look, I hear you, but I despise gay marriage. I don't like gays. I don't like the activity. Any of it, I wasn't raised this way. It's wrong. What do you think I would say to that person? I would say, let's go where? Let's go to the coffee shop. Because what you are saying to me is how you feel. And although that should be respected, equal respect should be conferred on those who feel differently. The same respect that you are insistent upon, you should confer to other people. What is the difference? At no point have I suggested for you to change your belief, change your religion, alter how you live as a person or as an individual. The only issue is one of law. And that is, are we at a place where reasonable people can disagree? I want to ask a second question. In the event they cannot, what's the justification? Some of you here will say, oh, Professor Moore, I'm so glad you asked. Let me tell you, we can't let gays get married. It would destroy society. Children can be harmed. Well, in a court of law, we have this little thing called evidence. It's a burden that is placed upon us that is objective in nature. What's the evidence to support it? Where's my affidavit? Where are the numbers? Where are my experts? Where are they? Where is the proof of this that you speak of? It's insufficient to feel a way and you cannot support it. I want to ask another question. In the event they cannot choose, what is the difference between a state disallowing two same-sex individuals from marrying versus disallowing Professor Moore marrying Professor Tonks? What's the difference? That was an example we started with earlier. I am obviously African American. She is Caucasian. We outlined it was not until 1967, which is not even 50 years, that this right as a matter of law was conferred upon Americans. So I'm saying to you, conceptually, what's the difference? There are people that would say and cloak this objection in religion. Professor Moore, I wasn't raised this way. Whites shouldn't marry blacks. Period, end of story. What would I say to that person? Let's go get some coffee. I respect your view. As long as you qualify it as one as yours. As long as you qualify it as one as an individual. As long as you qualify it as one non-legal. That should be respected. You have that right to believe that. You may be surprised at some of the things I may agree with you with as a matter of personal choice, but that's not why we're here. Okay? I may agree with some of your opinions, perhaps as strongly as you do, ironically. Where we part ways is the divorce between law and feelings. Let me ask another question. Broadly speaking, should the state be able to regulate private conduct that takes place between consenting adults in the privacy of their own homes? Consenting adults, meaning of age, in the privacy of their own homes. Let's say I was a single man. Okay, we're going to get a little out there, so just bear with me. And I meet Jane and Christine at a club. I'm 25 and single. We okay? All right, we're going there. Here we go. We're having a ball. We all go back to my place. Let's keep it clean. Let's say adult activities occur. Now, some of you would congratulate me. I know it's terrible. And some of you would be grotesque about what took place at my house with the legal adults that consented to our conduct. Should the state regulate? Should the state be in the business of regulating my private conduct with the consenting of age adults that participated. Is it okay if you disagree with what us three chose that night and still respect my right to do whatever it is we did? We kept it clean. Maybe we sang songs and ate cookies. We just kept it clean. But the point is one of a serious nature. Okay? Who is the government to regulate that conduct? That's why I put the Fourth Amendment on the board. Because the government can regulate conduct if it meets one of three exceptions. Do we remember? What's the first? Warrant? Probable cause? I'll be impressed if you get the third. Good, articulable suspicion. That's excellent. Articulable suspicion that criminal activity is afoot. Conversely stating, if the government cannot meet those three criteria, I have the right to be left alone. I have the right to be disagreed with. I have the right to be in my home doing whatever I am doing. The reason I stress the home is because it does matter where you are. I want to be clear. This is not something that's carte blanche. For example, if I choose to get intoxicated and pass out in my house, that is perfectly legal. You follow me? If I'm out at a club and do the same activity, I might be what? I might be arrested. That's a public place. So I'm not suggesting that any right is without limitation. If I get intoxicated and drive a vehicle, I might be what? Arrested, rightfully so. Because now I am not at home and it matters where I am and what I'm doing. Okay, I want to throw a couple more things out there and get some feedback from you guys. The idea of no right being absolute is one we're wrestling with. The Supreme Court did not go as far as stating that marriage was a fundamental right, such as voting, for example. But they came pretty darn close. And if you listen to the language that Justice Kennedy cited, what he basically said is, by the ruling in DOMA, it well arms any challenger of a state law forbidding same-sex marriage. In other words, he chided the court for saying that this should be allowed under federal law without touching the state law issue. Okay? Supreme Court did not go that far. They only addressed federal law, which is why you may be in a state legally married as a matter of federal law, but cannot claim marital status as a matter of state law. Hence the confusion. The other reason this is so compelling to me as an attorney is because I have been privy when people died. I've told my class, the Greeks were right. We are all doomed. There is no way out. It is a certainty. That's not to be morbid or negative, it's to be factual. That's how I get people to think about what will happen beyond their existence, because that will occur. Okay? That's the reason I posed the question to you earlier about having the religious ceremony on Monday and the marriage, actual signing of the contract on Friday, because many of you falsely equate the two. I'm not picking on any individual. You will say to yourself, because I feel married, because I love John or Jane, because we live together, Professor Moore, because he or she makes me feel a certain way, because we have children, we are married to us. What's my rebuttal? You are as single as that person is a stranger on the street. If you don't believe that, what's my evidence? Pass away. I cannot even speak to this person you claim to love, this person you had children with, this person who was so personally valuable to you. I will speak to your children, your lineal heirs, your descendants that we determine at death. That is the law. So much so, if you were married, I'm really going to pick a button here. And some of my students have said, Professor Moore, don't worry, I'm separated. It's all taken care of. Been separated 10 years. He does his thing, I do mine. It's all fine. What's my rebuttal? It is not fine. There is no ambiguity with marriage. You are single or married. If you were in love and died the day before the wedding, you're single. If you hated the person and married them and died the day after, you're married. There is no gray. This is the confusion when you get into estate law, because in many instances, I'm having to explain to children, I cannot speak to you. What do you mean? How could you say something like that? This is my mom. This is my dad. How I can say it is as a matter of law. That person has a living spouse. That's how I can say it. Many of you have parents, situations that are not my business, but I hope you're listening to me, because all of us will leave here. That's a fact. Okay? Go home. Hey, Mom, Dad, this crazy man said something to me today. Okay? If I can't go on the public record and find a divorce decree, you are still married. Okay? Not what I feel or think, as a matter of law. Are you with me still? A little bit? No? Let me read one more thing to you. With respect to other states, I want to give you some other names of Supreme Courts in other state bodies that have struck down similar legislation at a lower level. Are you guys listening? Some of these will be repetitive, some of them will be new. Massachusetts, Connecticut, Iowa, Vermont, New Hampshire, DC, California, New York, Maine, Maryland, Washington, Rhode Island, Delaware, Minnesota, New Jersey, Hawaii, Oklahoma, Utah, Virginia, are we still here? Texas, Michigan, Arkansas, Idaho, Oregon, Pennsylvania. So I'm closing because I want to get some feedback. I'm closing in saying a very serious issue. All of those judges that I have cited to you in respective ways are not uniform in the conduct. Where they are uniform is in the law, in not having a reasonable justification legally to treat people differently. The reason I mention race and marrying opposite races, because if you look at some of the dissenting opinions, even at the high court, you will see similar analogies, similar conceptual analogies. The court is saying, what is the difference? If you are going to say these people cannot have the same opportunity that us as heterosexuals have, you have to have a legal basis. You have to have evidence to support that basis, to defend that. Otherwise, you can respectfully disagree with it and let the law apply equally. Okay? Last thing I want to say is, we read a controversial case. Some of you may have heard there was a group out in the Midwest, and they were protesting against gay soldiers that had fallen deceased in the war. They were holding signs, and I don't even want to repeat some of the language in the signs. One of the students stood up and said, Professor Moore, have you heard of this case? I said, sure. And said, well, how do you feel about it? I said, well, that's not really relevant. I hope you guys understand why now. I said, I can tell you my legal opinion, and you can take me to get coffee and I'll tell you how I feel about it. But to make a long story short, the family sued because they felt their privacy had been violated. They were not able to bury their gay son, these people shouting certain things and holding up signs. They felt disrespected at the services of these fallen soldiers. What do you all think the Supreme Court said about the protest? Anyone? No? Yes, sir, in the back?
Legal?
It was legal. Gang, they were on the sidewalk. They were in public space. We pay for it as taxpayers. They weren't on the private cemetery grounds, which is why I'm qualifying the same conduct I gave you when I passed out drunk in my home, perfectly legal, versus being at a club or out in the street. Because they were on the sidewalk, they had every right to be there, peaceably assembled, our second qualification. They weren't advocating violence. They weren't advocating the overthrow of the government. They weren't inciting a riot. They were expressing their view peaceably. And as grotesque as you may think that is, do they have a legal right to do it? Yes. So the point again, the concept is the exact same. The divorce is the exact same in feelings versus law. Thank you. Now, you guys aren't my classmates, so I can't make you write a brief on it, but I would if you were in class. Anyway, because this is so special, I'll just take questions individually. I think that may be better. I want to thank Dr. Jackson for allowing me to speak. Eli, you were a great sport today. Lisa, really great for you guys. I'll hang around for a little while, then I have to eat. But thank you for coming, keeping an open mind. It was wonderful to speak to you.